So, Scott, my son is over at college, and he moved out of the dorms this year.
All right.
And so we got him an apartment that he shares with some roommates. And it's kind of a weird situation because it's an apartment that has like 5 bedrooms, and he has these roommates, and they share this apartment. They each have their own bedroom. Some of the roommates are his friends, but a couple of them he never met prior to this year.
Got it.
So I was thinking about this the other day. He just moved into this apartment about a month ago. They share, kind of the living room and the kitchen. They share the refrigerator. They have he has his food in there. And I was thinking about, if one of his roommates was to go into the refrigerator and eat some of his food, and maybe my son gets mad and they get into a fight, and it turns into a physical altercation, what kind of case could that be?
So it should first of all, if it's mutual combat, there should be no charges. A lot of times police officers will come out to a scene where 2 people get into it. You can't really determine the aggressor. And I've always argued that just because somebody won the fight doesn't make it a criminal case. Right. But it really does in the eyes of law enforcement. So if somebody ends up beating the heck out of if your son wins the fight,
the other guy has he's
liable to be arrested for just a regular misdemeanor assault.
Okay.
However, what we've been seeing is because they're roommates legally and meets the definition of assault, family violence, dating, household.
Right.
Okay. Which is still the same thing, still a misdemeanor. But it has other consequences. Mm-hmm. So go ahead.
And I was going to say, and part of the reason it's, a family violence case is because of the way that the Texas Family Code defines family violence. Family violence is an act by a member of a family or a household against another member of the family or a household. And households defined as just persons living together in the same dwelling.
Right.
So this would qualify as family violence.
It qualifies as family violence for sure. Whether it should really be done as family violence, different prosecutors would weigh in differently on that. When I was a prosecutor, I wouldn't have taken it as family violence. I don't want to get too much in the weeds on this issue, but so generally, when you have just say it's a really legit family violence case where a guy assaults his living girlfriend, okay, they don't have to put in the charging in for the misdemeanor information that family member or a dating relationship. They could just say assaulted this woman by striking her with his hand. Mm-hmm. And then the court can make the family violence finding or member of household or dating relationship, that family violence finding after the conviction. Okay.
But the charging it as a family violence case, when people get charged with the family violence case from the outset, there's additional consequences than you might find in a regular assault case, right? You were getting
all kinds of different things happen.
So what, for example?
So first off, if you're convicted, not deferred adjudication, but if you're convicted and there's a family violence or household, so every time I say from here on in family violence, that includes a household member, like you said.
The scenario with my son.
Exactly right. Okay. So if you're convicted and there's a family violence finding, under federal law, you can never own guns or ammunition the rest of your life.
Okay. So that's lifetime.
Yeah.
Wow.
Yeah, that's forever. Okay. The other thing is, even if you get deferred adjudication, so it's not a conviction, so it doesn't invoke the federal statute, and now you get into another fight with another roommate, now it can become what we call an assault second, where you have one adjudication or conviction. Doesn't have to be a conviction for this, an adjudication.
Like you got probation.
You got deferred adjudication, probation.
Right.
Okay. Not a conviction.
Right.
Okay. But now you get in, and so you can prove that prior was against a family member or a dating person or a household member. Mm-hmm. Now you have another assault against the same type of thing. Now it becomes a felony punishable by 2 to 10 years
in prison.
Yeah.
Yeah. Yeah.
Now I'm not saying you wouldn't get probation on that felony,
right?
But it's probation that if you mess up, you're looking at 2 to 10.
Right. It's a much more serious offense.
Completely different. I mean, nobody wants to have a felony conviction.
Well, not only that, but when you get charged with these family violence or household violence cases, there might be additional conditions just on your bond while you're awaiting, your trial, while you're going to court. There's additional conditions that they can put on you.
Right. The new statute we talked about two episodes ago, where you have to be held for an extra 4 hours if it's a family violence household assault. You're very much likely to have a GPS monitor on your ankle if you have that type of charge. And so I would encourage law enforcement to not charge because that's not the intent of the family violence statute, is 2 roommates get into a fight.
Right.
That was never the intent. Okay. I don't know if I mentioned this on a prior episode, but when I was prosecuting in Medina County, we had the sheriff's department trying to file family violence assault cases on two guys went on assault at the jail.
Okay.
Okay, so two guys were in jail, so they're sharing a dwelling, and they filed as a family violence assault because they're same household, the jail. I'm like, we're not doing it that way. No,
right.
It's just a regular assault. There's nothing wrong with just calling it a regular assault.
Right. And I know that, when you were a prosecutor at the Bexar County DA's office, you handled a lot of family violence cases. And I can always imagine that those are difficult cases to prosecute. But because oftentimes, correct me if I'm wrong, the complaining witness, the person who's on the receiving end may not want the case to proceed.
Right. And so when I first started doing this in like 1996, okay, we had just started going forward on cases without the victim's permission.
Okay. So that's a scenario where maybe in the scenario you gave, the live-in girlfriend says, hey, I don't want this prosecuted. I want it dropped. I don't want you to carry it forward. And
we didn't care. We went forward anyway.
Okay.
So there's confusion on this issue because a lot of people will say, oh, well, because it's a family violence case, you can't dismiss it. We can dismiss it if the case sucks. Mm-hmm. Okay. But if the case is good, if we got a 911 call saying he's beating me up and there's pictures of bruises, we're taking what the victim wants to do out of the equation about how we pursue it. Mm-hmm. And there's a big reason for that.
And what is that?
Because back in the old days, you used to have these guys beat up their wives every time they got drunk. And they would keep coming down and swearing out at things, saying, I want to pursue charges. And the charges would be dismissed. And the officers got sick of coming out to that house every month.
Right.
And back in the 90s, I knew as a misdemeanor prosecutor in Bexar County that the rate of family violence assaults always went up when the Cowboys lost.
Oh, wow.
Yeah.
I didn't know that.
No, when the Cowboys lost, we had a bunch of family violence assaults. Now it's so commonplace that nobody cares anymore. So you can't sit there because you don't know what's going on in the household. So is he intimidating her to get her and saying, I'm going to beat you even worse if you don't try to get these charges dropped? Right. We have to take that whole thing out of the equation and say, you violated the law. The police came out to your house and made an arrest. Whether the victim wants to pursue the charges or not, We'll listen to it, but it's not really relevant to what we're going to do with the case.
And that does cause confusion because from time to time, we get the complaining witness or the victim on the case saying, hey, I told the prosecutors I want this case dropped. Why haven't they dismissed it yet?
Right. So that as a defense attorney, our clients get mad, like, well, why haven't you got this case dismissed yet? My girlfriend doesn't want to pursue. I'm like, because they have good evidence. I mean, sometimes those 911 calls are very compelling. Mm-hmm. And nowadays, most jurisdictions, when the officer comes out, there's body cam. Mm-hmm. And so everything she said to the officer about what he did is captured on body cam. Mm-hmm. And so now she may come in and say, I lied to the police officer, but we don't believe it's a lie. We believe that what she said when it happened is more accurate. That's why there's an exception to it in the evidence code, why you can call it an excited utterance.
Right. So you have a situation where the officer arrives, he's running his body cam, and you have, the girlfriend, crying with a bloody lip, and the guy outside without a shirt pacing back and forth or whatever the case may be.
Right. And sometimes the body cam's catching the guy saying, you better shut the hell up, right? And that's a damn good case for the prosecution. I don't even need her to come.
Right.
I have the pictures. The officer can identify the parties. We have video of the body cam. We have a 911 call. I just need to put that officer on. I can prove the whole case through the officer. So so as prosecutors, we are required to listen to the victim when they call, but we're not required to do what they want.
It's not their case.
It's not their case.
It's the state's case.
Yeah.
Yeah. And so, what I found interesting is the law on family violence has been evolving.
So much.
I've been practicing 20 years, and, I remember back before we had laws like continuous family violence. And so could you explain what that is?
So going back to the 90s when I first started doing this, you could assault your girlfriend or your wife time and time again, and every time it would just be a new misdemeanor. Mm-hmm. So you've already known that you're only getting a misdemeanor for it. It's not stopping. Okay. And so I think it was in 1999 when they first passed the law saying, okay, and this is similar to what other states had done before Texas got around to it, is so if you assault a family member or somebody you're dating or member of a household and you plead to it, Now, if you do it again, it becomes a felony, the assault second we mentioned earlier in the show.
Right.
Okay. And so when that happens, now you're looking at a felony rather than a misdemeanor. And so that happened. So actually, originally, when they passed the law, they made it assault third.
Okay.
So back in the late 90s, they made it like the DWI statute. You had to have 2 family violence adjudications, and the third one became a felony. That only lasted 2 years. The next legislative session, they said, well, this is silly giving them 2 assaults before. And then, so the very next legislative session, they said, no, once you have 1 prior, the second one becomes a 3rd-degree felony, 2 to 10. Then in the 2000s, they created the continuous family violence statute you mentioned, because what we were having a problem is you still, in order to make it an assault second, there had to be a plea.
Right. The case had to be, that first assault had to be finalized with either a conviction or a plea.
Correct. And so what you were having is people assaulting their girlfriend or wife, and then because they hadn't got the charges dismissed, assaulting them again, and we still couldn't do it as a felony yet. So they created the statute called continuous family violence, meaning if you have 2 assaults within a 12-month period, again, and it doesn't have to be against the same person.
Right.
Okay. You could assault your mother in June and assault your girlfriend in July, and both of these cases are still pending. But instead of having 2 misdemeanors now, they're going to combine these 2 incidences and create it as a continuous family violence assault. Once again, 3rd-degree felony, punishable by 2 to 10, but they have to prove both separate incidences beyond a reasonable doubt. Okay. Generally, as a prosecutor, usually on those continuous cases, we had one really good offense and one that was kind of shaky.
Right.
Okay. But you have to prove up both of them.
Both of them during the trial for the conviction.
Correct.
Yeah.
Yeah.
And so, in those circumstances, when you were prosecuting these cases, I'm not asking for a percentage, but just generally speaking, how often were you dealing with cases where the victim didn't want to pursue charges?
Well, it felt like around half the time.
Okay.
Okay. And I had victims who would come in. So here, this is important for everybody to know. If you're feeling like that if things, we hear this all the time, it got blown out of proportion, right? How many times have you heard that? So I do want to listen to what the victim is telling me. And I've had victims come in and they lie to me right off the bat.
What do you mean? How do you know they're lying?
Because I'll say, well, you're saying that the police shouldn't have done this, but you called the police. And they're like, oh, no, it was a neighbor called the police. Now, I haven't listened to the 911 call yet. And I'm like, are you sure? Because I'm going to go listen to it. No, I never called the police. I go listen to the 911 call. They called the police.
Right.
You can hear their voice, right?
Crying on the phone.
Right.
Yeah.
And so now they're not credible to me anymore.
Right.
Okay. And so now they have much less effect. Like what they want to see happen has much less influence on me.
Right.
Okay. So don't lie to people when you're trying to be honest about it, and you have a better chance. I've had victims sit down with me. I actually had a victim once say, I am not afraid of my boyfriend. I can take my boyfriend. I was a female wrestler. I'll if you want to wrestle me right now. And she convinced me to dismiss the case. She didn't put me in an arm bar or anything, but she did convince me that because what we worry about, we don't want somebody to get killed by the person they're in love with.
Right.
Okay.
Right.
And we never know which are the cases that are like really dangerous and which are the cases that it's got blown out of proportion. We have no magic way. You
don't know what the dynamic is in that household.
All we can do is look at the facts of this particular case and see how bad it is. When we hear threats of like, I'm going to kill myself, or if I can't have you, nobody will, makes us nervous.
Absolutely. I'm sure.
And so when you hear that kind of stuff going on, you'll be like, I'm not dismissing this case.
Yeah.
If I lose it in trial because she wants to get up and say it never happened, but in all honesty, I never lost a case where the victim testified for the defense and said it never happened.
Wow.
I've lost plenty where they got up and said, I want him to go to jail forever. Yeah. But when they got up and said it didn't happen, the jurors never bought that stuff.
Yeah.
They know what's going on.
So we have plenty more to talk about when we come back after the break.